I inherited $425,000 from my grandmother. My family sued me for it. They lost. But let me back up, because the story of how I got here involves 10 years of Sundays, a visitor log that became courtroom evidence, and a family that only remembered I existed when there was money on the table. My grandmother, Helen, lived in a small ranch house about 40 minutes outside the city. The kind of place with lace curtains, a porch swing that creaked, and a garden she tended like it was her full-time job. She raised 4 kids in that house. My dad was the oldest. Then came Aunt Linda, Uncle Rob, and Aunt Sharon. I was the middle grandkid. Not the oldest, not the youngest, not the golden child, not the baby. Just there. My older cousin Jennifer was getting her PhD. My younger cousin Tyler was some kind of soccer prodigy. And me? I worked in IT support, lived in a 1-bedroom apartment, drove a 10-year-old Honda Civic that made concerning noises on cold mornings. Nobody expected much from me, which, honestly, was fine. I'd gotten used to being the background character in everyone else's highlight reel. But Grandma Helen? She saw me. It started 10 years ago. I was 23, fresh out of college, drowning in entry-level job applications and student loans. Sunday dinner at Grandma's was a family tradition that everyone had slowly abandoned. Dad was always too busy with work. My aunts and uncles had their own families, their own Sunday plans. The cousins? Forget it. They had brunch with friends, gym sessions, dating app meetups. So one Sunday, I showed up alone. Grandma opened the door in her floral apron, surprised. "Just you today?" "Just me." She smiled, but I saw something flicker in her eyes. Disappointment? Loneliness? Maybe both. We had pot roast. She asked about my job search. Actually listened when I talked about the rejection emails, the ghosting recruiters, the feeling that I'd never figure it out. She didn't offer solutions or tell me to work harder. She just nodded and said, "You'll find your way. You always do." I came back the next Sunday, and the one after that. It became our routine. Every Sunday at 2 p.m., I'd drive 40 minutes to that little ranch house. We'd have dinner, watch Jeopardy, talk about everything and nothing. She'd tell me stories about raising kids in the 60s, working as a seamstress, how Grandpa died too young and left her with 4 kids and a mortgage. I'd tell her about my week, the difficult clients, the co-workers who took credit for my work, the slow climb from help desk to systems analyst to senior IT specialist. She celebrated every promotion like I'd won the lottery. When I finally moved from that terrible shared apartment into my own place, she insisted on seeing photos. Called it palatial, even though it was 500 square feet and the shower pressure was more like a suggestion. Years passed. My visits never stopped. Dad would call every few months. "How's Mom doing?" "Good. I just saw her Sunday." "Oh, that's good. I should visit soon." He never did. Aunt Linda would text, "Tell Mom I love her." But she lived 20 minutes away and hadn't visited in months. Uncle Rob sent birthday cards. Aunt Sharon called on holidays. The cousins sent occasional Facebook messages with lots of emojis, but zero substance. And every Sunday I showed up. When Grandma was 78, she was diagnosed with breast cancer. The family group chat exploded with concern. Prayers, crying emojis. "We're here for you, Mom. Whatever you need. Family is everything." I drove her to every oncology appointment. 12 weeks of chemotherapy, sat in those terrible waiting rooms with fluorescent lights and magazines from 2015. Held her hand when the nausea got bad. Brought ginger ale and crackers. Learned which foods didn't taste like metal to her anymore. The family group chat went quiet after week 2. Dad: "Can't make it to the appointment, work emergency." Aunt Linda: "I'm so sorry, I have Tyler's tournament." Uncle Rob: "Out of town for business." Aunt Sharon: "Sending prayers." Prayers. Great. Super helpful when you're holding a vomit basin at 3 a.m. Grandma went into remission. The family celebrated with a dinner at a nice restaurant. Everyone showed up for that. Took photos. Posted them on Facebook with captions about strength and family bonds and never giving up. I'm in exactly one photo, half cropped at the edge of the frame, holding a water glass. 3 years later, The cancer came back. Metastatic. Stage 4. Lungs and bones. The doctors gave her 6 months to a year with aggressive treatment, 3 to 6 months without. She chose treatment. I drove her to appointments twice a week now. Radiation on Tuesdays and Thursdays. Oncology check-ins every Friday. Plus our regular Sunday dinners, though she couldn't eat much anymore. We'd watch Jeopardy and she'd doze off halfway through, exhausted from fighting a war inside her own body. The family group chat was active again. Lots of, "How is she?" and "Thinking of you, Mom," and "We should visit soon." But the visitor log at the cancer center told a different story. See, they make you sign in every time. Name, relationship to patient, time in, time out. It's for tracking, for security, for insurance purposes or something. I never thought much of it. I'd sign, name, my name. Relationship, grandson. Time, 2 RPM. Every Tuesday, every Thursday, every appointment for 18 months. When Grandma moved to hospice care in the final 8 weeks, they had a visitor log too, a clipboard by the front desk. I signed it every single time. 52 weeks a year, minus the week I had the flu and she made me stay home. Do the math. That's a lot of signatures. My dad visited twice during those 18 months. Once for 15 minutes when his work conference happened to be nearby. Once for her 79th birthday, stayed for cake, left before presents. Aunt Linda came 3 times. Uncle Rob, twice. Aunt Sharon managed 1 visit, cried the entire time, and had to leave because it was too hard. The cousins? Jennifer sent flowers. Tyler sent a card. That was it. I'm not saying this to sound like a martyr. I didn't keep score. I showed up because she was my grandma, and she'd always shown up for me, even when I was the forgotten middle grandkid nobody noticed. But someone was keeping score, whether I knew it or not. Grandma Helen died on a Tuesday morning in February. I'd visited the night before. She was barely conscious, but she squeezed my hand when I said goodbye. The hospice nurse called me at 6 a.m. She went peacefully. She wasn't in pain. I'm so sorry. I sat in my car in the parking lot of my apartment complex and cried for the first time since I was a kid. Then I called my dad. She's gone. He was quiet for a long moment. I'll call everyone. We'll plan the funeral. The funeral was 3 days later. Beautiful service, standing room only. Apparently, Grandma had friends from her church, her old sewing circle, neighbors who remembered her kindness. The family sat in the front row, dressed in black, tissues in hand, looking appropriately devastated. Dad gave the eulogy, talked about what an amazing mother she was, how she taught him about strength and resilience, how family was everything to her. I sat in the second row and said nothing. At the reception afterward, Aunt Linda hugged me. Thank you for being there for her. I know you visited a lot. Every Sunday, I said. For 10 years. She blinked. 10 years? Really? Really. She looked uncomfortable. Well, that's really good of you. I wanted to scream, but I just nodded and excused myself to get coffee I didn't want. The family gathered at Dad's house that evening, somber, reflective. Someone ordered pizza because nobody felt like cooking. We sat around pretending this wasn't weird, that we were a close family mourning together. Dad cleared his throat. So, about Mom's estate. Here we go. She had a will. I'm the executor. I'll be handling everything through probate court. It shouldn't take too long. Uncle Rob leaned forward. What's in the estate? The house, some savings, life insurance, investments. I'd estimate around $600,000 total, give or take. $600,000. The room went silent. You could see everyone's brains recalculating their relationship with Grandma, suddenly remembering how much they'd always loved her. How's it divided? Aunt Sharon asked. Dad shifted. I haven't opened the will yet. That happens through the probate process. Court has to authenticate it first, but I'm sure she divided it fairly among the 4 of us. Maybe something for the grandkids. Everyone nodded. Fair? Reasonable? Grandma was nothing if not fair. Except, 2 months later, I got an envelope in the mail. Official letterhead. Probate Court, County Clerk's Office. Notice to interested parties. Estate of Helen Margaret Anderson. My stomach dropped. This was it. The official notification that probate had been filed, that the will was being processed. I opened it. Primary beneficiary. My full name. Distribution. $425,000 after estate expenses, taxes, and executor fees. Secondary. Beneficiaries. None other distributions. $0. I read it 3 times. Then I sat down on my apartment floor, still holding the letter, and tried to process what I was seeing. $425,000. To me? Only me? Nothing to Dad. Nothing to my aunts and uncles. Nothing to the cousins. Grandma left me everything. My phone started ringing that evening. I ignored it. 12 missed calls. 23 texts. The family group chat was on fire. Dad, we need to talk. Now. Aunt Linda. This is a mistake. Mom wouldn't do this. Uncle Rob. Did you know about this? Aunt Sharon. How could she leave us nothing? Jennifer. This doesn't make sense. Tyler. UDF, dude. I turned off my phone and sat in silence for 3 hours. Then I called the one person I trusted. My best friend Marcus, who happened to be a lawyer. Corporate law, not estate law, but close enough. Read me the letter, he said. I did. He was quiet for a moment. Holy shit. Yeah. Okay, first things first. This is legal. Probate court wouldn't send this if the will wasn't valid. Your grandma had every right to leave her estate to whoever she wanted. But why me? You know why. I did know. 10 years of Sundays. Every appointment. Every hospital stay. Every moment when I showed up and nobody else did. She'd been keeping score after all. They're going to fight this, Marcus said. You know that, right? Can they? They can try. Will contests are hard to win, but families do it all the time. Usually they claim undue influence, that you manipulated her into changing the will. I didn't even know she had a will. Doesn't matter. If they're pissed enough, they'll try. He was right. 1 week later, I got another letter. Not from probate court this time. Petition to contest. Will, estate of Helen. Margaret Anderson. Grounds. Undue influence. Lack of testamentary capacity. Petitioner. My father's name. Executor and interested party. My dad was suing me, not just him. The petition listed all 4 siblings as co-petitioners. Dad, Aunt Linda, Uncle Rob, Aunt Sharon, a united front. Their argument was simple. Grandma must have been manipulated. She wasn't in her right mind. I'd isolated her from the family, taken advantage of her vulnerability, coerced her into leaving everything to me. It was bullshit, every word of it. But it was also strategic. They had nothing to lose. If they won, they'd split $600,000. If they lost, they were already getting 0. I called Marcus again. I need a lawyer. Yeah, you do. I'll send you some names. Estate litigation specialists. This is about to get messy. How messy? Discovery, depositions, medical records, financial records. They're going to examine every interaction you had with your grandmother for the past 10 years, looking for anything suspicious. There's nothing suspicious. I just visited her. Then you'll be fine. But it's going to be a long process. Months, maybe longer. And expensive. How expensive? Legal fees could run $15,000 to $20,000, maybe more if it goes to trial. I felt sick. I was about to inherit $425,000, but first I had to spend $20,000 defending my right to it. Do it, I said. Send me the names. Marcus paused. For what it's worth? Your grandma knew exactly what she was doing. She didn't leave you that money by accident. I knew he was right. But knowing didn't make the next 8 months any easier. The lawyer Marcus recommended was named Sarah Chen. Mid-40s, sharp suit, the kind of handshake that told you she didn't lose often. We met in her office downtown. Glass walls, city views, framed law degrees from schools I couldn't afford. She had the probate petition printed out, already marked up with highlighter and notes. Your father's case is weak, she said, before I even sat down. But that doesn't mean it won't be expensive and time-consuming. How weak? Undue influence requires proof that you manipulated your grandmother, isolated her from family, took advantage of her diminished capacity. From what you've told me, none of that is true. It's not. Good, because they're going to spend the next several months trying to prove otherwise. She slid a document across her desk. This is their discovery request. They want everything. I scanned the list. Medical records, financial records, phone records, email history, text messages, social media posts, a list of every interaction I'd had with Grandma for the past 10 years. They're also requesting depositions, Sarah continued. They'll question you under oath for several hours, possibly multiple sessions. They'll try to trip you up, find inconsistencies, make you look calculating or manipulative. I wasn't. I know, but they'll try to make it seem that way. Questions like, did you know about your grandmother's financial situation? Did you discuss inheritance with her? Were you aware she was updating her will? I didn't know anything about her will. I found out the same time everyone else did. Perfect. That's your answer. Short, clear, honest. She leaned back in her chair. Here's what's going to happen. Discovery will take 6 to 8 months. They'll examine every piece of evidence. If they find nothing, and I don't think they will, the case gets dismissed. If they find something questionable, we go to trial. And if we go to trial? Jury decides. But honestly, I've seen the pattern here. You visited consistently for a decade. Your father and his siblings barely showed up. Any jury will see that. So why are they doing this? Sarah smiled grimly. Because they have nothing to lose. They're getting zero either way. Might as well roll the dice. Hope you'll settle just to avoid the hassle. I'm not settling. Good. Neither am I. The deposition happened 6 weeks later. Conference room at my father's attorney's office. Bland corporate art on the walls, a table long enough for 12 people, and a court reporter with one of those stenography machines that looked like it came from another century. My father sat across from me. We made eye contact exactly once. He looked away first. His attorney was a guy named Richard Brennan. Late 50s, expensive suit, the kind of lawyer who probably charged $500 an hour to tell you things you already knew. Sarah sat next to me. Remember, short answers. Don't elaborate. If you don't know something, say you don't know. Don't guess. Brennan started with softballs. My name, my address, my occupation. How long I'd known the deceased. Then he shifted. When did you first discuss your grandmother's will with her? I didn't. Never? Never? You visited her every week for 10 years and never once discussed what would happen to her estate after she died? That's correct. That seems unlikely, Sarah cut in. That's not a question, Brennan rephrased. Did you know your grandmother owned her home outright? I knew she lived there. I didn't know the mortgage status. Did you know she had substantial savings? I knew she lived comfortably. I didn't know specific amounts. Did you know she had life insurance? No. Did she ever mention updating her will? No. Did she ever mention previous versions of her will? No. Did she ever express dissatisfaction with her children? I hesitated. That was a trap question. She rarely spoke negatively about anyone, I said carefully. But she did speak negatively about her children? I didn't say that. You said rarely, which implies sometimes. Sarah leaned forward. You're twisting his words. Move on. Brennan smiled like a shark. Did your grandmother ever express frustration that her children didn't visit more often? Another trap. Answer yes, and I'm manipulating her feelings. Answer no, and I'm lying. She mentioned she wished the family was closer, I said, but she didn't blame anyone specifically. Did you encourage those feelings? No. Did you ever say negative things about your father or aunts and uncles to your grandmother? No. Not once in 10 years? Not once. He didn't believe me. I could see it in his face. But he moved on. How many times per week did you visit your grandmother in her final year? Twice a week for medical appointments. Once a week for Sunday dinner. More often during hospice. So you were there more than her own children? I don't know how often they visited. Approximately? You'd have to ask them. I'm asking you. I can't speak to their schedules. Brennan pulled out a document. This is the visitor log from hospice care. 8 weeks of care, 540 hours of operation. You signed in 63 times. Your father signed in twice. Your aunts and uncles combined signed in 6 times total. Sarah objected. Is there a question? Yes. Brennan looked at me. Doesn't that level of isolation qualify as undue influence? Cutting off the family's access to the decedent? I didn't cut anyone off. The hospice was open to everyone. They chose not to visit. Or perhaps you made them feel unwelcome? How would I do that? I don't control hospice policy. But you were there constantly, every day, according to this log. Don't you think that might have made other family members uncomfortable? I felt anger rising but kept my voice level. I was there because she was dying and I didn't want her to die alone. If that made anyone uncomfortable, that's not my problem. Sarah squeezed my arm gently. Warning. Brennan continued for 4 more hours. Every question designed to make me look calculating, manipulative, greedy. Did I ask her for money? No. Did she give me gifts? Sometimes, small things. Did I do work on her house? I fixed a few things. Did she pay me? No. Did I expect payment? No. By the end, I was exhausted. Brennan looked frustrated. He hadn't gotten what he wanted, a confession, a slip-up, anything to justify the lawsuit. We'll reconvene after reviewing the medical records, he said. Outside, Sarah looked pleased. You did great. He got nothing. It felt like he got a lot. He got you saying, I don't know and no for 4 hours. That's exactly what we wanted. No contradictions, no admissions, no elaboration. Perfect. What's next? They'll subpoena medical records, phone records, financial statements. It'll take 2 months to gather everything. Then we wait for their next move. The medical records arrived first. Grandma's entire oncology file. Treatment notes, doctor's assessments, mental capacity evaluations. Sarah sent me the relevant summary. Patient demonstrates full cognitive function throughout treatment. Alert, oriented, able to make informed medical decisions independently. No signs of diminished mental capacity. Patient's grandson, my name, listed as primary emergency contact. Patient requested he be present for all major medical decisions. Family involvement minimal. That last line was pure gold. The phone records came next. 10 years of call logs between me and Grandma. 523 phone calls. Average duration, 18 minutes. Pattern. Consistent. Weekly. Sometimes daily during medical crises. Calls from Dad to Grandma. 47 over 10 years. Average duration, 6 minutes. Aunt Linda? 32 calls. Uncle Rob? 21. Aunt Sharon? 63. Apparently she called more than the others, though she rarely visited. Sarah was thrilled. This is devastating for their case. You can't claim someone isolated the decedent when the phone records show consistent family contact, and you certainly can't claim it when your own call logs are 10 times less frequent than the defendant's. Financial records were the final piece. Every transaction in and out of Grandma's accounts for 10 years. No suspicious transfers to me. No large cash withdrawals. No sudden changes in spending patterns. Nothing that suggested financial manipulation or exploitation. Actually, the records showed the opposite. 3 times over 10 years, I'd sent her money. Once when her water heater died, $800. Once when she needed new tires, $450. Once for Christmas when I knew she was worried about bills, $300. She'd tried to pay me back each time. I refused. The bank statements showed she'd written those checks anyway. Made them out to me. I'd never cashed them. They'd expired after 6 months. Sarah highlighted those in her motion to dismiss. Your Honor, the defendant not only didn't exploit the decedent financially, he actively supported her when she needed help. This is the opposite of undue influence. But the family wasn't done yet. Month 6 of discovery, they subpoenaed the hospital staff. Dr. Patricia Morrison, Grandma's oncologist for 3 years. Nurse Jennifer Walsh, who'd worked with her during chemo. Social worker David Park, who'd coordinated hospice care. All three gave depositions. Sarah got the transcripts first. Called me immediately. You need to read these. Now. I opened the file. Deposition. Dr. Patricia Morrison. Brennan. Did you have concerns about the patient's grandson's level of involvement? Dr. Morrison. Concerns? No. Relief. Most patients going through cancer treatment are alone for appointments. He came to every single one, took notes, asked intelligent questions, made sure she understood her treatment options. Brennan. Did he ever seem controlling? Dr. Morrison. Controlling? He was supportive. There's a difference. He advocated for her, but he always deferred to her decisions. Brennan. Did the patient ever express feeling pressured by him? Dr. Morrison. Never. She spoke about him constantly, said he was the only one who showed up. Those were her exact words. I had to stop reading, put the document down, stared at the wall for a minute. The only one who showed up. That's what she'd told her doctor. I kept reading. Deposition. Nurse Jennifer Walsh. Brennan. How often did you see the grandson during the patient's treatment? Walsh. Every Tuesday and Thursday for 18 months. He had a chair in the corner of the chemo suite. We called it his spot. He'd sit there for 4 hours while she got treatment. Brought her water, held her hand when she felt sick, made her laugh when she was scared. Brennan. Did other family members visit? Walsh. I saw her son twice in 18 months. Once during a weekday, stayed maybe 20 minutes. Once on her birthday, brought a cake but left before treatment ended. I remember because the patient cried after he left. Not from pain. From disappointment. Brennan. Did the grandson ever discuss inheritance or financial matters? Walsh. Never heard him mention money once. He talked about normal things. Work, movies, weather, Jeopardy episodes. Just life. Like he was visiting because he wanted to, not because he wanted something. Brennan. Did the patient ever seem confused or diminished in mental capacity? Walsh. Mrs. Anderson? No. Sharp as a tack until her final week. She knew exactly what was happening, made all her own decisions, never lost her awareness. The social worker's deposition was even better. Deposition. David Park, hospice social worker. Brennan. Did you have concerns about the family dynamics? Park. I had concerns about the lack of family support, yes. The grandson was essentially providing 24/7 care in the final weeks. Other family members were notably absent. Brennan. Did you discuss this with the patient? Park. I did. Standard protocol for hospice care. We assess family support systems. Mrs. Anderson told me her children were busy with their lives. She didn't seem bitter about it. Just factual. But she was clear that her grandson was her primary support. Brennan. Did she ever express concern about his motives? Park. The opposite. She said, and I'm reading from my notes here, I don't know what I did to deserve him, but I thank God he shows up. Everyone else forgot about me years ago. Brennan. Did you witness any behavior from the grandson that seemed manipulative or coercive? Park. Absolutely not. I've worked in hospice for 12 years. I've seen family members who isolate patients, control information, manipulate medication schedules, pressure for financial gain. This wasn't that. This was a grandson who loved his grandmother and didn't want her to die alone. Period. Brennan. No further questions. Sarah sent me a message after I finished reading. This case is over. They have nothing. I'm filing a motion to dismiss next week. But the family wasn't ready to give up. Month 7, they requested a second deposition. This time, they wanted me to bring physical evidence. Every card Grandma sent me, every gift, every photograph. Anything that could possibly suggest our relationship was transactional. I showed up with a shoebox. Inside, 43 birthday cards spanning 10 years. Christmas cards. Thinking of you cards. Most were generic Hallmark. Some had $5 bills tucked inside. Grandma's way of saying she wished she could give more. Photographs, printed photos from Sunday dinners. Me and Grandma at her kitchen table. Me and Grandma in her garden. Me and Grandma watching Jeopardy. All dated on the back in her handwriting. One photo I'd forgotten about. Taken by a hospice nurse 3 days before Grandma died. Me asleep in the chair next to her bed, still wearing my work clothes. Grandma's hand resting on my arm. The nurse had written on the back, "This is what love looks like." Brennan examined each item like he was searching for hidden evidence. Found nothing. Just 10 years of a normal, loving relationship between a grandmother and her grandson. He tried one last angle. Why do you think your grandmother left everything to you? I'd been waiting for this question for 7 months. Because I showed up. That's it? You showed up so you get $400,000? I didn't show up for money. I showed up because she was my grandmother and I loved her. If she left me nothing, I'd still have shown up every Sunday. But she didn't leave you nothing. She left you everything. That was her choice, not mine. A choice you benefited from tremendously. Yes, and I'm grateful. But I didn't earn that money by being strategic or manipulative. I earned it by being present. There's a difference. Brennan stared at me for a long moment, then closed his folder. I think we're done here. Outside, Sarah was smiling. That answer was perfect. I showed up. That's going to be the quote I use in every motion from now on. Is it really over? Almost. I'm filing the motion to dismiss tomorrow. Given the evidence, or lack thereof, the judge will likely grant it. They'll have 30 days to respond, but they have nothing to respond with. And if they don't give up, then we go to court. But they won't. Not after seeing those depositions. The medical staff testimony alone destroys their case. I wanted to believe her, but I'd learned over 7 months that my family was stubborn, entitled, convinced they deserved something they hadn't earned. They had one move left, and they were going to make it. 2 weeks later, I got a text from my cousin Jennifer. First contact since the lawsuit began. We need to talk, just us, no lawyers. I showed Sarah the message. Don't respond, she said immediately. What if she wants to apologize? She doesn't. She wants information, or she's going to try to manipulate you into settling. Classic litigation tactic when you're losing. Separate the opponent from their lawyer, make a personal appeal. What if she's sincere? Sarah gave me a look that said I was being naive. These people are suing you. They've spent 7 months trying to prove you manipulated a dying woman. They don't get to have a friendly chat now. She was right. I didn't respond. But the attempts kept coming. Uncle Rob called. Left a voicemail. Can we talk? Family to family? This has gone too far. Aunt Sharon texted, Your grandmother wouldn't want this. Let's work this out. Dad sent an email. I'm willing to negotiate a settlement. Let's end this. Sarah's response to all of it. Ignore. They're panicking. Then came the Facebook post. Aunt Linda, on her personal page, set to public. Sometimes family betrays you in the worst ways. Manipulation. Greed. Taking advantage of a sick, vulnerable woman. But karma is real. The truth always comes out. Justice will be served. Comments rolled in. Friends and cousins who didn't know the full story, offering support. So sorry you're going through this. Family can be the worst. Stay strong. I stared at the post for 20 minutes. Felt rage building in my chest. Then I did something I'd been avoiding for 7 months. I took a photo of the hospice visitor log. The one showing 520 visits from me, 2 from Dad, 6 total from everyone else. Posted it on Facebook with a simple caption, 10 years, 520 visits. Actions speak louder than words. Tagged my entire family. And waited. The Facebook post went viral overnight. 4,000 shares. Hundreds of comments. Aunt Linda deleted her original post within hours, but the damage was done. Screenshots of the visitor log, 520 visits versus 2, spread across grief support groups and estate forums. Sarah called at 7 a.m. Your father's attorney requested an expedited hearing. They want this over before the social media storm gets worse. 2 weeks later, I walked into the county courthouse. Modern building, fluorescent lights, uncomfortable chairs. Courtroom 4B, Judge Patricia Holloway presiding. My father arrived with Brennan and my aunts and uncles. We made eye contact through the glass doors. Nobody waved. This is what $400,000 does to a family. The courtroom was small, maybe 50 seats, half of them empty. No jury. This was just a motion hearing. Judge Holloway would decide alone whether the case had enough merit to proceed to trial. Sarah had explained the standard. If the family couldn't show genuine evidence of undue influence, the case would be dismissed. If they showed even minimal questionable evidence, it would go to trial and a jury would decide. Judge Holloway entered. Late 50s, black woman, no-nonsense expression. She'd been on the bench for 15 years according to Sarah's research. Former prosecutor. Reputation for cutting through bullshit. Be seated. Case number 2024 PR 8847. Estate of Helen Margaret Anderson. Motion to dismiss filed by defendant. Mr. Brennan, you have 20 minutes to convince me why this case should proceed to trial. Brennan stood. Confident, rehearsed. Your Honor, the petitioners are not alleging simple favoritism. We're alleging a systematic pattern of isolation and manipulation spanning 10 years. The defendant inserted himself as the sole caregiver, sole decision-maker, sole influence in the decedent's final years. He was present for over 500 medical appointments and visits while the decedent's own children were effectively shut out. Judge Holloway interrupted. Shut out how? Was the defendant preventing family members from visiting? Not explicitly, Your Honor, but his constant presence created an environment where, Counselor, I'm asking a yes or no question. Did the defendant prevent the petitioners from visiting their mother? Brennan hesitated. No, Your Honor, but did the defendant control the decedent's phone access? No, but did the defendant isolate the decedent from medical professionals, clergy, friends, or community? No, Your Honor. However, the pattern of behavior, what pattern? That he visited consistently and they didn't. Judge Holloway flipped through the evidence file. I've reviewed the discovery materials. Phone records show regular contact between the decedent and all family members. Medical records indicate full cognitive capacity until the final week of life. Financial records show no suspicious transactions. What exactly am I missing? Brennan pulled out his strongest card. Your Honor, the medical staff depositions show the defendant was present for every single medical decision. He had complete control over the decedent's health care, because she listed him as her emergency contact, which was her legal right. Continue. I could see Brennan sweating now. This wasn't going the way he'd planned. Your Honor, the dispositive issue is the will itself. The decedent had 4 children, 7 grandchildren. She left everything to one person. That level of disproportionate distribution, combined with the defendant's level of involvement, creates a presumption of undue influence. Does it? Judge Holloway looked up. In this state, a testator has absolute right to dispose of their estate as they see fit. Unequal distribution is not evidence of undue influence unless accompanied by proof of coercion, diminished capacity, or isolation. You've provided none of those. She turned to Sarah. Ms. Chen, I'll give you 10 minutes, but I'm not sure you need them. Sarah stood. Calm, prepared. Your Honor, I'll be brief. The petitioner's case rests entirely on the premise that consistent caregiving equals manipulation. It doesn't. My client visited his grandmother regularly for 10 years before she was even sick. He continued visiting during her illness because he loved her, not because he wanted her money. She pulled out a document. I'd like to submit one additional piece of evidence. The decedent's previous will, executed 6 years before her death. Brennan shot up. Objection, Your Honor. This wasn't disclosed in discovery. Because we just obtained it from her attorney yesterday. It's a prior version of the same will. Identical distribution. Everything to the defendant, nothing to others. Judge Holloway took the document. Read it silently. This will was executed 6 years ago? Before the decedent's cancer diagnosis? Yes, Your Honor. The only thing that changed in the final will was updated executor information. The distribution remained identical. That landed like a bomb. 6 years ago, Grandma had already decided to leave everything to me. Before the cancer, before the intensive caregiving, before any of the family's allegations about manipulation could have even been possible. Judge Holloway looked at my father. "Mr. Anderson, you're listed as a petitioner. Stand up, please." Dad stood, looked uncomfortable. "Mr. Anderson, when did you last visit your mother before she entered hospice care?" Dad cleared his throat. I'm not sure of the exact date, Your Honor. Approximately. Maybe 6 months before. And during her 18 months of cancer treatment, how many times did you visit? I called regularly. I asked about visits, not phone calls. Dad looked at Brennan, who nodded slightly. Twice, Your Honor. Twice in 18 months. And you're alleging that your son, who visited over 500 times, manipulated your mother into cutting you out of her will? Your Honor, I was working. I had responsibilities. We all have responsibilities, Mr. Anderson. Your mother was dying. Your son made time. You didn't. That's not manipulation. That's consequences. The courtroom went silent. Judge Holloway closed the file. Here's what I see. A grandmother who made a difficult but clear-eyed decision about how to distribute her estate. She chose to leave it to the family member who showed up consistently, who provided care when she needed it, who made her end of life less lonely. That's not undue influence. That's gratitude. She looked at Brennan. Your clients are upset because they were disinherited. I understand that. But being upset doesn't create a legal claim. You've provided no evidence of coercion, no evidence of diminished capacity, no evidence of isolation. What you've provided is evidence that your clients didn't visit their dying mother as often as they should have. Brennan tried one last time. Your Honor, if we could just... Motion to dismiss is granted. Case dismissed with prejudice, meaning it cannot be refiled. Furthermore, under state law section 33-15-14, when a will contest is filed in bad faith without reasonable grounds, the court may award attorney's fees to the prevailing party. She turned to Sarah. Ms. Chen, submit your fee statement within 30 days. Mr. Anderson and co-petitioners, you'll be jointly responsible for paying the defendant's legal costs. She banged the gavel. We're adjourned. It was over, just like that. 8 months of discovery, dozens of depositions, thousands of pages of evidence, and it ended in 20 minutes. Sarah grabbed my arm. Don't react, not yet. Wait until we're outside. We walked out of the courtroom in silence. My father and his siblings stayed behind with Brennan, probably getting the bad news about how much this was going to cost them. Outside on the courthouse steps, Sarah finally smiled. That was a massacre. I've never seen a will contest shut down that brutally. What happens now? I'll submit my fee statement. Legal fees, expert witnesses, court costs, everything. Probably around $15,000 total. The judge will review it, likely approve it in full, and your father and his siblings will have to pay it jointly. 30 days or the court can garnish their wages. $15,000. Split 4 ways, that was about $3,700 each. Not enough to bankrupt anyone, but enough to sting. My phone buzzed. Text from Marcus. Saw the court update. You won? Dismissed with prejudice. It's over. Sarah handed me her card. The money should transfer within 60 days now that the contest is resolved. Congratulations. Your grandmother would be proud. I thought about Grandma Helen, watching from wherever she was now. I hoped she was proud. I hoped she knew I'd fought for what she wanted. That evening, someone leaked the court outcome online. The comments on my visitor log post flooded in again. Update. Case dismissed. Justice served. The judge made them pay his legal fees. Beautiful. I checked my messages. Nothing from Dad. Nothing from any of them. Just silence. Which honestly was fine. 520 visits versus 2. The rest was just noise. 63 days after the court hearing, I got an email from the estate attorney. Subject. Final distribution. Estate of Helen Margaret Anderson. Attached. Wire transfer confirmation. Amount. $412,147.33. I stared at the number. $412,847.33. After probate fees, executor costs, legal expenses, and taxes, this was what remained. It hit my account the next morning. I logged into my banking app 3 times just to make sure it was real. The balance looked wrong, like someone had added too many zeros by mistake. But it wasn't a mistake. For the first time in my life, I wasn't worried about rent, or car repairs, or whether I could afford to fix my broken dishwasher or just keep washing dishes by hand. I sat in my apartment for an hour, just processing. Then I called my financial advisor. Well, the financial advisor I'd hired 2 weeks earlier when I knew this was coming. A woman named Patricia, who specialized in helping people who'd inherited money and had no idea what to do with it. First thing, she said, don't do anything dramatic. No Teslas, no boats, no sudden lifestyle changes. Let it sit for 30 days while we build a plan. I laughed. I was thinking about a used Camry. That's reasonable, but wait 30 days anyway. The first thing I actually bought was groceries. Real groceries. Not ramen and frozen pizza, but actual ingredients. Fresh vegetables. Good bread. Cheese that didn't come pre-sliced in plastic. I spent $80 at the grocery store and didn't check my account balance afterward. That felt like freedom. The second thing I did was pay off my student loans. $43,000, gone in a single payment. The balance went to zero. No more monthly payments. No more interest accruing while I slept. Just done. I cried a little when the confirmation email arrived. Not sad crying. Relief crying. Over the next month, I followed Patricia's advice. Paid off my credit card. Put $20,000 in an emergency fund. Invested $200,000 in index funds for retirement. Set aside $50,000 for a house down payment someday. Kept working my same job. Drove my same car. Lived in my same apartment. The only thing that changed was the weight I'd been carrying for 10 years. The weight of always being behind, always scrambling, always one emergency away from financial disaster. That weight was gone. 3 months after the court case, my sister Jennifer called. I almost didn't answer. We hadn't spoken since the lawsuit began. She'd been one of the signatures on the petition, one of the names demanding I be stripped of the inheritance. But curiosity won. Hi, she said, tentative, uncomfortable. Hi. Long pause. I wanted to apologize for the lawsuit, for not reaching out sooner, for everything. I didn't say anything, let her sit in the silence. I didn't know you'd been visiting Grandma every week. Nobody told me. I just assumed everyone was visiting equally, and when Dad said you'd manipulated her, I believed him. Why would you believe that? Because it was easier than admitting we'd all failed her. Easier than facing the fact that none of us showed up when it mattered. That landed. The visitor log, she continued. When I saw that photo, 520 visits. I felt sick. I visited twice in 10 years. Twice. And I lived closer than you did. Why didn't you visit more? I was busy, work, life, kids. All the usual excuses. But they were excuses. You were busy too. You still showed up. I could hear her voice cracking. I don't expect you to forgive me, or Dad, or any of us. But I needed you to know that I see it now. What you did. What we didn't do. And I'm sorry. I took a breath. Thought about holding on to anger, refusing the apology, making her hurt the way I'd hurt. But what would that accomplish? Thank you for saying that. Does that mean? It means I appreciate the apology. It doesn't mean everything's fixed. I'm not coming to family dinners. I'm not pretending the last year didn't happen. But I'm not holding a grudge either. That's fair. We talked for a few more minutes. Awkward small talk. She asked about my job. I asked about her kids. It wasn't warm, but it wasn't hostile. Before we hung up, she said one more thing. Grandma knew what she was doing, leaving everything to you. It wasn't about the money, it was about who earned it. Yeah, I think you're right. Dad never apologized. Not directly anyway. 6 months after the court case, I got a card in the mail. Generic sympathy card, the kind you buy at CVS. Inside, one sentence in his handwriting. Your grandmother would be proud of how you handled this. No apology, No acknowledgement of what he'd put me through. Just that one sentence. I threw the card away. Some people don't change. They just get quieter when they lose. A year after Grandma died, I drove out to the cemetery. Small plot, modest headstone. I'd paid for both with inheritance money. Nothing fancy. Just her name, her dates, and one line she'd told me she wanted. She showed up. I sat on the grass next to her grave, brought flowers, yellow roses, her favorite. Hi, Grandma. The cemetery was quiet. Just wind through trees and distant traffic. I wanted to tell you what happened. With the money. With the family. With everything. I told her about the lawsuit. About the depositions and the medical records and the visitor log that became evidence. About the judge who saw through the bullshit. About the money that finally transferred. I paid off my student loans. You would have liked that. You always said debt was a chain. I told her about the apartment I was still in. The job I still worked. The life that looked mostly the same from the outside but felt completely different on the inside. I'm not rich. I mean, technically, I guess I am now. But I don't feel rich. I just feel secure. Like I can breathe for the first time in years. A couple walked past, arm in arm, visiting a grave 3 rows over. They nodded politely. I nodded back. Jennifer apologized. I don't know if that matters to you. It mattered to me, a little. But Dad didn't. I don't think he ever will. I traced my finger along the edge of the headstone. I wanted to tell you something else. Something I didn't get to say before you died. The wind picked up. Leaves scattered across the grass. I didn't visit every Sunday because I knew you were going to leave me money. I visited because you were the only person in my family who actually saw me, who asked about my life and listened to the answers, who made me feel like I mattered. My voice cracked. The money is amazing. It changed my life. But that's not why I showed up. I showed up because I loved you. And I'd have shown up even if you'd left me nothing. I sat there for another 20 minutes. Didn't say anything else. Just sat. Before I left, I placed the yellow roses against the headstone. Thank you, Grandma, for everything, for seeing me, for the Sundays, for trusting me with this. I won't waste it. Driving home, I thought about the past year, the lawsuit, the depositions, the courtroom, the verdict, the money. But mostly I thought about 10 years of Sundays, pot roast and Jeopardy, cancer appointments and hospice visits. The moments nobody saw, nobody documented, nobody cared about until there was money involved. Those moments weren't transactions. They were just life. Showing up for someone you loved because that's what you do. The inheritance wasn't payment for caregiving. It was acknowledgement. Grandma's way of saying, I saw you too. I saw you showing up when nobody else did. And that mattered. Some people inherit money because of birth order or blood relation. I inherited money because I earned it. Not through manipulation or isolation or diminished capacity. I earned it by being present. By caring when it was inconvenient. By showing up every single Sunday for 10 years, not because I wanted something, but because someone I loved needed someone, and I was willing to be that someone. 520 visits. That's not a strategy, that's a life. And now, sitting in my apartment with a paid-off student loan balance and a retirement account that would actually let me retire someday, I finally understood what Grandma had been trying to tell me. Family isn't who shares your blood. Family is who shows up. And sometimes, the people who show up aren't the ones you expect. Sometimes, it's the middle grandkid nobody noticed. The one with the 10-year-old Civic and the IT job and the studio apartment. The one who just kept showing up. Even when nobody was watching. Especially when nobody was watching. That's who I was. That's who Grandma saw. And that's who I'll always be.